Good evening, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 5th, 2025. We're going to start off on voting list number 9, and we're going to start off with Senate Bill. Is Senate Bill 158, Senator West? Is that?
158 is
Decanting.
oh, decanting, yeah. I think it's ready to go.
Okay, we'll start off with that.
Senate Bill 158 established provisions governing the methods by which a notice may be given or documents can be sent under the Maryland Trust Decanting Act. Specifically, the bill requires that notice to a person or sending of a document to a person under the Maryland Trust Decanting Act has to be accomplished in a manner reasonably suitable under the circumstances and likely to result in the receipt of the notice or the document. For a fiduciary, an authorized fiduciary must provide notice to a person under the Act either by personal service, by certified or first-class mail, postage prepaid, return receipt requested, by courier delivery service prepaid, delivery confirmation requested, or if a person entitled to receive the notice agrees in writing to accept an alternative form of notice, the notice can be given by 1, first-class mail, postage prepaid, 2, fast mail transmission from a fast mail device that produces a confirmation page that specifies the date and time of a successful transmission, or 3, email acknowledgement requested. If an authorized fiduciary who provides notice by one of the alternative methods knows or should know that the person receiving notice did not actually receive the notice, the authorized fiduciary must provide notice by one of the 3 non-alternative methods. A person can revoke the authorized alternative method notice by providing notice to the fiduciary by one of the non-alternative methods. An authorized fiduciary can continue to provide notice using an alternative method until the person gives them notice of revoking that authorization.
I can explain this in a sentence or two. So when we passed the decanting bill last year, the people who gave me the bill from the States and Trust section of the State Bar Association assumed that the decanting bill would be lodged in the Maryland Trust Act, which has this elaborate notification provision specifying how notice is given. It turned out it was not put in the Maryland Trust Act, so it ended up in a part of the code with no notice provision. So all this bill take the same notice which is in the Maryland Trust Act, which they thought last year was going to apply, and put it in the decanting bill. So the decanting notice is exactly the same notice as is provided for all the other elements of the Maryland Trust Act. It's very simple.
Why wasn't it put in the Maryland Trust Act?
I can't answer that. The bill was given to me, pre-drafted, and I gave it to Legislative Services, and they drafted it. And for whatever reason, wasn't put in the Maryland Trust Act. It was put in a separate part of the Estates and Trust article. So all this bill does, again, is take the same notice provision that is in the Maryland Trust Act and add it so it applies to the decanting bill that we passed last year.
Okay, I don't have a problem with it. I just didn't know if there was a reason.
Yeah, I don't think there was a reason. Either was people didn't realize there's a problem that they were creating, but they did create a problem.
Thank you.
Is there a motion? Is a motion for a favorable? Second, is everyone okay with being recorded in the affirmative? All right, Senate Bill 158 passes unanimously. All right, so Senate Bill 12, you're withdrawing. Senate Bill 118 is on hold, is that right? That's right. I'm gonna do them all at the same time at the end.
Are we gonna do the speed camera one?
Hold on, is this one still working?
No, I think it's
Ready?
ready.
I don't want to get into that one. Let's jump down to Jamie. Are you ready for Senate Bill 360?
Senate Bill 360 authorizes a person to bring and maintain a civil action for defamation per se against another who distributes a computer-generated visual representation that is indistinguishable from an actual visual representation of the person and is of a sexual or intimate nature, which is specified in the bill. The bill also expands the state's existing prohibition against revenge porn to prohibit a person from knowingly distributing a computer-generated visual representation that is indistinguishable from another actual and identifiable person that displays the other person with his or her intimate parts exposed or while engaged in an act of sexual activity. Violators are subject to the existing penalties under the revenge porn statute.
I had a note that potentially under the bill, a person could be criminalized for presenting an image of themselves. Was that addressed by amendment, or is that?
So there's no amendment in your voting packet, but to answer the question, let me just pull up the, yeah, so in page 5, the new prohibition would be, the new prohibition would be that a person may not knowingly distribute a computer-generated visual representation that is indistinguishable from another actual and identifiable person that displays the other person with his or her intimate parts exposed or while engaged in an act of sexual activity. So in my reading of that, Senator, there's a distinction between perpetrator and victim in that the prohibition applies to a person and the victim is designated as the other.
Thank you for the clarity. Thank you.
Yeah, so we met, a few of us just to walk through this language, and there was, I think, a sort of consensus that perhaps section Roman 2 at line 10 on page 5 should come out, because unlike the part of the law that's current law which precedes it, in which the photo could have been taken with original consent that was then withdrawn, because this is a virtual representation of the person, that this language was unnecessary to the statute and may harm the ability to prosecute under the statute. Because if you're making pornography of using someone else's image, presumably, unless proved otherwise, that is without consent, versus a photograph that someone knows to have been taken and is shared without consent later.
Not to be weird and like, what if someone? The work groups, I just wanted to know, yeah.
Yeah.
I mean, I think, yeah, you could have, I think, a situation where both are true, and I guess it depends on what the committee or the body, would intend with it. I think you probably could imagine a situation where, yeah, somebody consents to the distribution of such a photo. And then the person who's doing the distribution has that intent.
Thank you. I agree then, and I do now with the vice chair's point, since the crux of this is that you are creating this visual representation, you're creating this deep fake, and you're distributing it with the intent to harm, harass, intimidate, threaten, or coerce. So to have that consent piece just doesn't make sense. Yeah, that's perfect word for it. Thank you.
Sorry, I just asked because I wasn't in the work group. Senator Sindor.
Now, Senator Love, she said create and distribute, but this doesn't seem to say anything about the creation. It's the distribution. Am I reading that right?
Right, it's the distribution. The creation, I think probably there might be more of a First Amendment argument in the creation of something than the public distribution of it.
So we're going after the people who have it and send it out, but not the person who created it.
Yeah, I would say that's correct.
Well, distribute. If you created it and you gave it to another person and he broadly shares it, you're still distributing it, right? I mean, like, you're still.
Well, right. It's not the.
It's not like
action that's being penalized by the
It's the
statute.
distribution.
It's sending it to somebody else. and
dissemination, whatever.
Presumably, that's I mean, it could be a limited audience or it could be a wider audience.
Which is the concern that I think I expressed before about some of these bills where we're trying to, instead of honing in on the main perpetrator, you could have many people down the line that could possibly, they put themselves in jeopardy.
You mean like down the line?
I've sent it to you. I created, I send it to you.
Yeah.
You're fascinated, you send it to someone else. So initially, I'm in jeopardy. Now you're in jeopardy. And every time it gets sent,
Right?
I think the person's in jeopardy.
Because each person
Is
is harming.
distributing it.
Each person is harming the victim.
Right.
Each time. Yeah.
Right, I mean, but in that.
People take intimate pictures of each other all the time, but to create something that inherently that person, unless they did it themselves or did it in conjunction with that person, they weren't present for the creation of it.
Yeah. They do seem somewhat incongruent, you're right. So I'm fine. I mean, Senator Sidnor.
The juvenile who violates this, is this going to be treated in juvenile, this is going to be treated in juvenile court, not adult?
Yeah, I mean, obviously, those cases could be waived up. I don't believe there'd be anything that would auto-charge somebody in adult court for a juvenile violation of this. But in the juvenile court's jurisdiction is, Josh, 13.
For this, it would be 13 or older.
Yeah.
And did I hear you correctly that you were saying that the way this plays out, if one of us were to take a picture or create this image of ourselves and then send it out, we're not having one of these the issues that we've had with
Self-pornography.
Right.
Right. Yeah, my read of this is you have a distinction between a perpetrator and a victim. What the statute uses is the word a person, which is, pretty typical in criminal statutes. It's a person is prohibited or may not. And then distribute a computer-generated visual representation that's indistinguishable from an actual and identifiable person that displays the other person with his or, so it's another person.
Oh, yeah.
So it's a distinction between perpetrator and victim is how I would read that. I wouldn't read that as sort of creating a sort of self-pornography issue.
Let me push on that a little bit. So you have some man who digitally enhances himself, sends it to a woman to harass her. he's caught up in this, right?
No.
He's not?
So the statute says, I'm looking at page 5, line 5, and it needs to display the other person. So it's an image that's displaying the other person with their intimate parts exposed or while engaged in an act of sexual activity.
Not the creators.
Not the creator, not the distributor.
Or the person can, okay. I'm just trying to think through the scenarios. I'm gonna be quiet for that.
Does the additional language in Roman numeral 2, is it designed to try to limit the scope to the person who is the original actor? If the additional elements have to be proved that the person knew that the other person did not consent or had a reckless disregard, in my mind, those other standards are placed on there so you kind of don't catch in the dragnet someone who got the video and thought, oh my gosh, look at this person, and they just continue to forward it. Because, I mean, you could get it and you could think negatively of someone and you could send that on, but you could have also thought they consented to it, but, you had no knowledge that there was no consent in the outset. And I think the harm is that the person doesn't consent and then someone distributes. But if you remove the knowledge of consenting or not consenting, then I think you open the dragnet for everybody else who may intend to harass or harm someone, but was not a part of the original generation of it in the original distribution, and you open the door so broadly. So I think there's value to the language in Roman numeral 2.
It's also a point, like, you could, this is a weird, we're going on these weird, like, paths, but, like, what if you consented, but then you revoked your consent? Like, I don't know. Like, do you know what I mean? Like, what if you said, hey, like, we can send these to our friends, and then, like, you break up, and then, I don't know. I guess then the consent is no longer there.
Did the distribution occur before they withdraw the consent?
No, yeah, before.
Before, then it was consented to.
Yeah. But that's what I'm asking. So like,
Show a reckless, I think under that circumstance, just so I'm clear, so it's a little convoluted. The victim has consented initially to a distribution. Subsequently, the victim, subsequent to the distribution, the victim withdrew the consent. But then some person down the line in that chain distributes it after consent has been withdrawn. That is a complicated case. But I think you would. No, I could imagine that it could happen, but I think there's a reckless disregard as to, it would hinge on whether there was a reckless disregard as to whether the person consented to the distribution.
what if it's years later?
If it's years later, I think that's probably the avenue that you would go for on a prosecution is that there was a reckless disregard, unless you could show clearly that the person didn't, that the perpetrator knew that the victim didn't consent.
Members of the committee, I listened to everything that you're saying, and I actually thought the work group's suggestion to take that out was a reasonable one, and that the adding in the consent might be confusing, but honestly, I don't feel strongly about it, and I think you could go either way and still have a solid bill.
strikes it closer to what I think is the original bad actor is who we want to hold accountable with this. I get if people are still doing it, you want to stop the distribution, but I think it's closer aligned with what I think our goal is, and that's at the beginning. I appreciate it. Yes.
No, I don't know how you clarify it any, I don't know how you clarify it anymore. I mean, yeah.
I just wanted to ask a question that you might not be able to answer. I asked my colleague, Senator Love, and I think she said the language came from another bill, this Roman numeral 2, 1 and 2, but here's what I'm trying to understand. When we are in other statutes trying to push back on harassment, intimidation, threatening, and coercing behavior, do we go to great lengths to talk about consent or reckless disregard or concepts similar to it?
Right, so. Right. So.
Yeah.
So I think I'd heard the comment that, in harassment generally, there's a warning that's required as a proof. But in this case, I think more to the point of your question, Senator, the General Assembly already has an existing prohibition, and actually on the bottom of the previous page, page 4, is where the existing prohibition on revenge porn starts. So I think to the point of that question, in a nutshell, the General Assembly did go to some length to address the consent issue with respect to this. And that requires showing that it was done with an intent to harm, harass, intimidate, threaten, or coerce the other person, and under circumstances in which the person knew that the other person did not consent to the distribution or with a reckless disregard. So that's mirrored in the existing language. The thing that is different about this is that the existing statute requires showing that it be under circumstances in which the other person had a reasonable expectation that the image would remain private. My sense in the language here is that most of these cases do not involve a victim actually knowing that the image was created in the first place. Right.
Visions that the person knew that the picture was taken.
Correct.
And under the second, it presumes that people do not know that the image was created.
Correct.
Yeah.
I was thinking about this summer because I had a client, I mean, I'm not disclosing anything proprietary, like I had a client that was going through a clearance process, and the whole kind of like the exchanging of pictures between minors was an issue that came up, and had it on the phone, but it was consensual at the time. Person aged out, is an adult now. The thing remains on the cloud, and then it like popped up, and the person was like, "Oh my God, is this like child stuff, or does this count now?" Because we're both like in our 20s. This was taken when we were 16, and I was thinking about this over the summer because when you have a cloud on your phone, like it ports every time you get a new phone. It still follows you. It's like the functional equivalent of like finding a Polaroid in your parents' attic from when you're in high school, and then you come back and you see it. Like, are you guilty then of like looking at whatever? So that's what I started thinking about when I first started reading the first part of the statute. Anyway, Senator Sidnor.
So for council, it's on line 5. It says another actual and identifiable person, and reading it so that we're giving each of the words meaning. I guess I'm wondering, do we need another actual and instead of just saying that is indistinguishable from an identifiable person that displays that person with his or her intimate parts. I mean, is there a reason why we're putting all the other language in?
So I read that as one clause, right? We're talking about not just not just an identifiable person, not just another person. We're talking about a person who is another and who is actually a person and who is identifiable. So the genesis of that and where that sort of comes from is mirrors language that exists in the child pornography statutes currently. Years ago, I believe it was maybe 2018 or 2019, the General Assembly addressed the deepfakes angle of child pornography and added that to the possession and distribution statutes. In order to pass constitutional muster in that context, the Attorney General had advised that because of, I think it was a case called Ashcroft versus Free Speech Coalition, that the First Amendment would have required that the image have actually been of a real person, not just look like a real person, but you needed to be able to essentially point to a real person and say that is the image of that person, and we can identify that person. So with that's sort of where that terminology exists in existing law now.
And
Is there a motion? Motion for favorable second. Is everyone okay? Is everyone okay being recorded in the affirmative? Okay. Senate Bill 360 passes unanimously. All right, let's do Senate Bill 466.
Just pull that up. This would be 466. Senate Bill 466 prohibits a caregiver, family member, or household member from knowingly and willfully taking property from a vulnerable adult or an individual age 68 or older with the intent to deprive the individual of that property. Violators are subject to graduated penalties based on the value of the stolen property. Violations constitute an unfair, abusive, or deceptive trade practice under the Consumer Protection Act, subjecting violators to the existing civil and criminal penalties of that act. There is an amendment, actually, it's not an amendment in your voting packet, but it is a copy of the House bill as amended by the House. The Attorney General had come in during the bill hearing and requested amendments, and I believe that the version that the House had prepared was consistent with those that request for an amendment. So in your voting packet, there's a copy of House Bill 604, which is the cross-file to this bill. And the amendment struck the bill pretty much in its entirety, and instead modified the existing statute on obtaining by deception, intimidation, or undue influence property of a vulnerable adult. The new language actually begins on page 10 in the reprint of, or the third reader version of House Bill 604, and provides that a person who is a caregiver to or a family member or household member of an individual may not knowingly and willfully obtain the property of the individual with intent to deprive the individual of the individual's property if, One, the individual is a vulnerable adult or an individual who is at least 68 years old. And two, the person knows or reasonably should know that the individual is a vulnerable adult or is at least 68 years old. There's also a provision on page 11 that provides that a sentence imposed for conviction under subsection B3 of this section, which is what I just read to you, shall be concurrent with and not consecutive to a sentence for any crime based on the act or acts establishing the violation.
So, thank you, Mr. Chair. I just wanted to, we had discussed this a little bit earlier, and, on 466 on page 5, line 19, I have a concern that we're putting in statute that the age of 68, because it was either or, not that just that they were diagnosed as not being competent or whatever the specific language said. But now we're putting in statute an age that basically is going to say that they're vulnerable. It was vulnerable adult, I'm sorry. So that they're a vulnerable adult with a diagnosis. So, we have people that are in their 50s that have Alzheimer's. We have people that are beyond, in their 80s who are sharp as a tack. But by this, we're going to say, oh, well, now if, we're putting something in law and statute that says if you're beyond 68, you're considered vulnerable. And then it comes to a whole other thing, which is what I brought up about, well, it doesn't look like Musie's, 75 age for judges is ever going to happen, because apparently at 68, you're not really competent after that anymore, according to some areas of the law. So I just, I don't know if we took any,
I think they made it a little better in the House, though.
I don't know if we had any, I don't know if what was any further discussion beyond that, Mr. Chair, but that was, I don't support having an age. I mean, if they're a vulnerable adult, I'm all about it. Support them, do what we got to do to protect them. But if we're going to put a specific number on it, I think that that's a really, I don't agree with that at all.
Actually, even the House got it wrong on page 10. They got to
Yeah, they have it on there.
clean it up a little bit, but they made it better. Yeah. Big typo. Sorry.
Am I understanding it right that if the person is a caregiver or a family member, we're removing the requirement for deception, manipulation, or threat? Because if I am managing the finances of someone and I'm their family member and I pay a bill or do something with it, I'm depriving them of their property. But if I don't have the intent to be deceptive, manipulative, or threaten a vulnerable adult, is it oversimplifying? Let me take one step back. Am I understanding it right that we're removing the element of deception, manipulation, undue influence if that person is a caregiver or family member?
So, in a nutshell, yeah. I will add the caveat that the intent needs to be to deprive, which is a defined term under 7101 of the criminal law article. And if you give me just a second, Senator, I can pull that up for you.
But it's also to obtain the property.
To obtain the property of the individual with intent to deprive them.
So two quick things. To Senator Henson's question, I think we do need to dig into that a little bit more, but it says knowingly and willfully obtain the property. So I would read that not to be paying a bill, but we definitely should clarify that. And then to Senator Folden's question, we already have the 68-year-old phrase in statute. So we're not adding it?
It wasn't.
Well, if you look on page 10 of the reprint.
Above, yeah, but
It's different, though. It's not, because we talked about that in the back. The application of that number.
Right, but I'm just saying, this is not something new that we're creating. It's
Yeah, I
already
just think, I understand, and I appreciate that. I'm
Right.
just saying that when we start doing it by the vulnerable, when we're associating vulnerable or 68, and then we're having these discussions, like I can tell you, like my grandmother just passed away. My uncle stopped working to take care of her. So he paid for everything for her, for maintenance and care of her, and was still very sharp, but she was quite elderly. The way, like, I believe what Senator Henson is saying is that it's not through deception or anything. He was just maintaining the finances, paying taxes, doing these other things, but he's also living there. So could someone say, well, he's taking advantage of this because these are being paid for out of her funds or doing this versus because he had to quit work to take care of her because they couldn't afford to, pay for a 24-hour nurse. If because he stopped working, now he's living solely off of those checks with her, and he pays his car payment out of that because he's got to get her to doctor's appointments. And the way I understand it, and I believe to your point, Senator, is that that could be eligible for this crime by removing the portion about deception.
And that just to make sure we address your concerns, so and Senator Love, so if council could read the definition of obtain and deprive, obtain and deprive is a statutory definition. I want to make sure we just have it read for folks to understand, and then I want to move on to the 68.
So the word obtain here would mean, in relation to property, to bring about a transfer of interest in or possession of the property, and in relation to a service, to secure the performance of the service.
But that's exactly what I'm saying. So my uncle, who stopped working, but because he had to stop working, still has a vehicle, but he needs that vehicle to take her to appointments. If he pays for, now that she's the sole, that source of income that she has and still gets to her retirement checks or whatever going into Social Security and whatnot, by the way this is written, if he makes a payment for his vehicle, or even for tax purposes, you're saying that she's a vulnerable adult, she doesn't have the ability to give him the authority, so he's paying for that. He could be ruled if there was an inter-family struggle that didn't agree with him being there, that person could say, you know what, you're taking our family money and you're paying your car payment, so this is a crime.
So if you're, transferring that, you're doing that transaction for their benefit. The second question is, does that meet the definition of deprive? And so if you could just read that.
But I think what we're talking about is that we're talking about removing the language through what Senator Henson's point was, and I'm drawing a blank on exactly the language, but it was about through deception and things like that. Where that I think it's important to have in there, because through the example I'm giving you, it's not through deception, it's through necessity.
No, so I guess, but that's where the definition of deprive comes in, because I just want to read that because I think it's going to give us more context. Because is it a deprivation of your property if you're obtaining it to pay a bill for them on their behalf? That's not necessarily a deprivation.
I understand what you're saying, but you have many family disputes where the family is in having dispute over the remaining estate, the finances and things of that nature, and where someone leaves or is able to leave their job and go live with the person, you have others that are like, oh, you're just trying to take the property, I know what you're doing. And then by the way that this is written, if you remove that, I believe that would qualify that they could be charged with this crime.
Especially if you have an inter-family.
Senator James.
So under 7101 of the criminal article, deprive means to withhold property of another, 1, permanently, 2, for a period that results in the appropriation of a part of the property's value, 3, with the purpose to restore it only on payment of a reward or other compensation, or 4, to dispose of the property or use or deal with the property in a manner that makes it unlikely that the owner will recover it.
So start allowing someone that lives there, and all of a sudden they could be, I've seen it happen to my in-laws. My father-in-law, his mother passed away, and his stepfather still lived, but the stepson intervened and took care of dad and had everything signed over to him upon their mutual estates interest when he would normally die or when he passed away. And when he did, that was a malicious attempt, an intentional attempt to deprive everybody. So through the deprivation, the intent is important is what I'm saying. And I think that by removing that, it leaves too much inference for people to be able to come in and over an estate issue and make an argument and potentially levy charges. I'm good.
So I think Bill is onto something here. Let me give you a hypothetical. I go to my grandmother's apartment, and she's over, what is the year, 68? And I said, Granny, I've always loved that antique rifle you have here. And, you know, would you be willing to give it to me? And she said, you're my favorite grandson. Of course I'd be willing to give it. Go ahead and take it. So I take the rifle back to my house, and you tell me, based on this language, why I could not be indicted for having violated the statute. So I knowingly and willfully obtained the property. I asked her for it. She gave it to me. So knowingly and willfully, I obtained the property with the intent to deprive her of her property. And looking at it, I'm taking it permanently for a period that results in the appropriation of part of the property's value with the purpose to restore it only on the payment of a reward or other compensation. We never talked about that. And dispose of it in a manner that makes it unlikely the owner will recover it. So I got that antique rifle, and I have violated the law unless we put language about, you know, fraudulently or maliciously or something like that in there to modify what I did. But merely asking for a gift and accepting the gift seems to put me in violation of this law.
So, Senator, just sort of giving an equivalency on it for information, if you look at language in the general theft statute, there is a prohibition under 7104, it's 7104A, provides that a person may not willfully or knowingly obtain or exert unauthorized control over property if the person intends to deprive the owner of the property. So there are other modalities of theft that can occur, but in sort of that situation that you were describing, that language does seem to pair up with the new language here with the additional requirement that it be a vulnerable adult or a person over the age of 68.
Tell me what my attorney could, if I were indicted, you know, other members of the family complained, my grandmother died. They said, where's the antique gun? And Chris got it. And so I get indicted. What would my attorney, or how could my attorney argue that this language did not cover me? What would the argument be based on the actual language?
I think my reading of the word deprive is that the property is still rightfully the property of the other person. It's not merely that it's been transferred from one person to another, because then it would become your property. But the definition of deprive means to withhold property of another under those any of those four circumstances.
But in the case of a gift, the person who gave the property is giving away, is no longer the property of another. It's the person gave it away. So I just think that it's a difficult situation. And wouldn't it be better to have a couple of adjectives like fraudulently or willfully or maliciously or something like that in there to separate a gift from more venal ways of getting hold of property?
Was just my quick question was to try to find out why the Attorney General needed this, because I'm reading his letter to us. So the two situations above 3 have the language about that we're comfortable with, and he's making a case which I haven't finished reading. Obviously, that he thinks there should be a third category without this language. So I bet you read the Attorney General. So the question is, what is the Attorney General trying to accomplish by removing the willful and deception, intimidation, under influence language? And What's he trying to accomplish that he's not able to accomplish under the law now?
So we're going to actually have a representative from their office come in and help us with this, so.
Okay, sorry,
Yeah.
I thought somebody
No.
actually knew. I wasn't,
No,
it's
no.
not a trick question or
No,
anything.
no, no, it's not, no, not at all. And
So in the spirit of helping out, can I make a motion that we move the bill eventually?
Eventually. When we got it. Yeah, right.
All right, so Senate Bill 466 is held. We'll have to address this tomorrow, though, because it has to go to Triple E. It's cross assigned, so we'll get there tomorrow. All right, let's go to Senate Bill 581.
Senate Bill 581 increases from $10,000 to $25,000 the maximum amount of compensatory damages that may be awarded to the owner of a pet from a person who tortiously causes an injury to or the death of a pet by the person's own actions or through an animal under the person's ownership, direction, or control.
All right, motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Going to hold tomorrow. 567, we're going to hold until tomorrow, just with the sponsor's consent. So. Senator Charles, so we're going to wait for a delegation letter for 585?
Yeah.
Or 525?
We were supposed to have a delegation meeting tonight, but got canceled.
Okay.
So once we get back on the delegation.
Well, let me know. I mean, all right, we'll come back. We're holding 525 because no delegation. Senate Bill 500 is held because we don't have a delegation letter.
Oh, wait, hold on, we just got a bunch.
Oh, we did?
Yeah, hold
All
on.
right, let me give you time to go look at that then.
We just got, yeah, 600.
All right, I'll wait till you guys go. What about Josh, Senate Bill 590? Shit. Waiting for them? All right. Yeah, we can certainly amend the bill right now.
If you want to do the amendment.
Yeah, let's do, and there's an amendment here, so let's do that. I'm going to be on the,
I don't think it's in the packet.
yes. Okay, how long will that take?
About like 5 minutes.
5 minutes, okay. So there's an amendment we need to adopt, and we'll do sponsor amendments, but, so it's going to happen in 5 minutes. We're going to move on to another bill, then we'll do that, make sure. Yeah. So we're going to do all of the withdrawn unfavorable, so that's Senate Bill 512 and Senate Bill 729. And
Keep flipping.
Senate Bill 884.
No, Senator Muse, they're withdrawn. They're all withdrawn.
Okay, and so motion's withdrawn. Is everyone okay being? Yes, sorry. So, go ahead. Yes, John.
Senate Bill 12 was also,
I think I said that. Yeah, I said that the first time.
512 is what you said.
Oh, oh, so my bad. Yeah. All right. Senate Bill 619.
Senate Bill 619 proposes a constitutional amendment that would authorize the chair of the Commission on Judicial Disabilities to take certain actions in the event of a member's recusal, disqualification, or expiration of a member's term without replacement. It authorizes the chair to recall a former member to serve temporarily, or request that the governor appoint a temporary substitute or extend a current member's term. Any substitute member is still subject to the same qualifications that were applicable to the member that they are substituting for.
So motions for favorable has been seconded. Is everyone okay being recorded in the affirmative? Okay, no worries. Take time. Okay. Senate Bill 619 passes unanimously. All right, so we're going to do Senate Bill 622.
Senate Bill 622 repeals a requirement for the state reporters to secure a copyright for the state of Maryland for opinions of the Supreme Court of Maryland and the Appellate Court of Maryland designated for publication by respective courts. This is currently their practice, so this is just updating the code to reflect that.
Motions for favorable has been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 622 passes unanimously. No, so.
Court of Maryland sessions.
Yeah, 629.
Senate Bill 629 authorizes the Appellate Court of Maryland to hold sessions at secondary and post-secondary educational institutions in the state as designated by the Chief Judge of the Appellate Court of Maryland in conjunction with the administrations of secondary and post-secondary educational institutions. There is an amendment in your packet that is just a technical correction to make sure the cross-references are covering the right paragraphs.
The movement's amended, it's been seconded. Now the bill's before you as amended. Motion's been for, favorable, it's been seconded. Is everyone okay being recorded in the affirmative with the amendment? All right, Senate Bill 629 as amended passes unanimously. So Senate Bill 649, we are so close, Senator Muse. So, yeah, 655. This is John Edwards.
Senate Bill 655 establishes an artificial intelligence evidence clinic pilot program in the Administrative Office of the Courts to, 1, provide expertise in artificial intelligence to the circuit courts and the district court in the form of expert testimony on the authenticity of electronic evidence that a court determines may have been created or altered using artificial intelligence. 2, engage specified students, faculty, and technology professionals to develop expert witness resources for courts to use in cases implicating use of artificial intelligence. And 3, prioritize civil cases in which one or more parties do not have legal representation or reasonable access to expert testimony. The Administrative Office of the Courts must issue a request for proposals to select an entity to manage the program. For fiscal year 2027 and 2028, the governor may include in the annual budget an appropriation of $250,000 for the program. There is an amendment in your packet that eliminates all of what is in current subsection D, which required the Administrative Office of the Courts to request proposals for the program and established the minimum requirements for those proposals and preferences for certain proposals. Instead, it creates a general requirement for the office to develop a grant application for the program and award grants to eligible institutions of higher learning.
On the amendment. So, all right, so now the bill, so the amendment's been adopted, everyone's okay? That, now the bill's before you as amended. Discussion. The motion, is that, is a motion for favorable, or do you want to, okay, motions for favorable, it's seconded. Is everyone okay being recorded? Any from? 1 second. Senate Bill 655 with amendments passes unanimously with the amendment. And that's John again. Senate Bill 797.
Senate Bill 797 authorizes Dorchester County to enter into a lease of a county property without giving notice as specified if the lease has a term of 5 years or less.
All right, there's motions for favorable and seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 797 passes unanimously. So 710. You want to be on it? Yeah, so let's just, so let's pull up 710. So now we're going to go back to Senate Bill 590, and the amendments have been distributed. So everyone should have a hard copy amendment on their desk.
Let me just get the 710 there for Jamie.
How many amendments is 2 or 1?
2.
So my apologies, two amendments. Josh, you want to go ahead and read?
So Senate Bill 590 makes changes to the offenses of negligent driving, reckless driving, and aggressive driving. So on negligent driving, it increases the maximum penalty from $500 to $1,000. For reckless driving, it adds a potential penalty of 30 days of incarceration, increases the points assessment to 6 points, and also clarifies that speeding in excess of 30 miles an hour or more over the speed limit constitutes reckless driving. For aggressive driving, that is currently defined in statute as during a continuous period of driving, committing any 3 or more of a list of 7 specified offenses. Under the bill of as drafted, it would make that 2 or more of the following offenses, and it would add 12 additional offenses to go up to 19 offenses. The 2 amendments that were just distributed is first is number 613-420/1. This just adds the name Sergeant Kep to the title of the bill. And the other amendment is 123-920/1. So that would revert the change from 3 of the following offenses to 2, so it would now be 3 of the following offenses, and the list is being expanded from 7 to 19.
All right, just real quick, let's move the non-substantive amendment first. So if we can move Amendment 613-420/1, is everyone okay adopting that? All right, excellent. All right, further discussion on the second amendment, Amendment 123-9201. Okay, so I'm sorry, Senator Love, we're on this. Okay, excellent. So is everyone okay? All right, now the bill is before you as amended, so let's just work off of that second amendment for discussion, because you want to be added on? All right. So, hold on, give me a second. Let's give council a second here. I would like to be added on as well. So James would like to be added on. Hold on a second.
Golden, James, West.
West,
Smith.
me. Okay. Is everyone okay adopting the sponsor amendments? Okay, excellent. Who was on that work group? Okay.
Voting on 590 tonight?
No, we can't.
Okay, I'll reserve for the voting session. Thank you.
Senator Love.
Thank you, Mr. Chair. I believe this came up at the hearing, because I have a note on it. So on page 2, line 25, on the original bill, not on the reprint, when we add at a speed at least 30 miles per hour above the posted speed limit, in adding all of that, I want it to be clear that that does not apply to automated enforcement. And my note says no, because they don't know who is driving, but I think we need some clarity, either by doing it right now, so, the judicial record shows that this doesn't apply to automated enforcement.
Applied to, because it didn't specifically say it had to be an officer to actually issue the citation, not, because it affects the person, not the registrant.
Right.
So it's separate. So
Okay.
the automated enforcement is a separate fee schedule. It does
Right.
not apply.
Okay, good.
And-
I just want the legislative record to be clear.
Also, just to drill down on that, the automated, the speed camera provision states that violation it's a defined term in there to mean a violation of the 21809, so it would not include anything related to reckless driving.
Right.
All right, we're not voting it tonight anyway, but so we can have further discussion on it, though. Good, bye. Okay.
Thank you.
So we're holding it. We're holding this, why are we holding this? Oh, why are we holding 590?
Because B&T has to be here.
Oh, okay. All right. Thank you.
Sandy, can you answer this? I don't want to keep asking, but on 710, I know we're waiting on B&T. Is that what we're waiting on to add any of the to add the co-sponsor? All right, I'm just trying to keep track. Thank you.
Oh, yeah, that's a good one, too.
And then 640 or whatever.
All right, just so you know, so with the sponsors' consent, we're holding Senate Bill 343, and then we can go on to, Senate Bill 338. Is that?
Yeah, that's fine. That's fine. Yep. I'm going to vote against it, but yeah, but I want to be able to vote against. Yes. It's getting kind of late. It's 6:48. He's trying to get you music.
I'll vote for you.
I just don't, I worry about it being moved and then tomorrow, and then it gets voted on tomorrow, and then Monday night it gets voted on, and I'm not gonna be here. I'm not
So
coming
Senate
back.
Bill 364.
Huh?
We're not even on three.
What'd you say?
SB 364.
364.
It could be tomorrow.
What?
If we move something tonight, does it go to second reader tomorrow? Potentially?
We haven't talked about it.
No, I mean, okay, so now we're gonna go to 364.
Senate Bill 364 increases the maximum incarceration penalties for manslaughter by vehicle or vessel through gross negligence from 10 years to 20 years for a first conviction and from 15 to 30 years for a subsequent conviction. So just for some context, what counts as a prior conviction for the purposes of this offense includes the similar offense of causing death by criminal negligence, as well as the offenses of causing death while operating a motor vehicle while impaired or under the influence of alcohol, as well as all DUIs. So those all trigger subsequent offender penalties that are being affected by this bill.
Were these, because this was about the boating accident, right?
Yes.
It does cover vessels.
So it goes, okay, so, it's vehicle or vessels. Okay. I'm just trying, I'm trying to think comparable penalties. I mean, increasing from 10 to 20 and 15 to 30. Okay, thank you.
I'm going to apologize because I remember we had a couple of different work groups in the back, and the topic vessel was brought up, and I don't know if it was this one, Josh, but when we were talking about like jet skis, that was the reckless operation on the water, right? It's not this one, because this one actually deals with the death of another. I know we've had a lot of work groups, so but do you remember us discussing the actual term of vessel, because it would have included jet ski, and we didn't want to, that wasn't this one though, I don't think.
There is a similar provision which I think was discussed, but is not part of either bill, which is causing death by criminal negligence, which currently does include, that does say vehicle or vessel. So both of these offenses are rear.
So I guess I would ask the same thing that Senator Sidnor said. Do we have, what is the current time of incarceration for vehicular?
The criminal negligence, first offense is 3 years, and a subsequent offense is 5 years.
For the motor vehicle law?
For both motor vehicle and vessel.
For kills.
This is, so the provision being amended in 364 is the gross negligence.
Okay.
The similar criminal negligence statute is 3 years, 5 years for subsequent law.
This is.
Okay, so is there, we discussed this the other day also in this work group about criminal gross negligence in the operation of a motor vehicle, right?
So the
What,
two separate standards. One is criminal negligence.
correct,
And you should be aware of the risk. but you
Correct.
don't perceive it.
correct.
Gross negligence is a conscious disregard of the bills.
All right. And this is changing the gross negligent portion, which is currently 10 and 15?
It's currently 10 to 15, and the bill changes to 20 to 30.
Criminal negligence is 3 First
What,
offense.
can we, yeah, I'd like to talk to my colleague from Baltimore County.
I mean, it isn't a mandatory sentence, but it's quite dramatic.
All right, Senate Bill 418.
Senate Bill 418 authorizes the Carroll County Department of Human Resources to request a state and national criminal history records check from the Criminal Justice Information System Central Repository, or CJIS, for any prospective employee or volunteer of Carroll County. It does this by repealing a provision that limits which employees or volunteers may undergo a criminal background check.
It's been a motion for a favorable. Senator Love.
So I'm confused. Don't we have a statewide policy on ban the box? And isn't this going backwards?
So
418.
yeah, for specific information on the prohibitions in what can and can't be asked in a job application or an interview, I would need to get back to you, Senator, on that law. I believe when that was passed, I remember that going through Finance Committee, so I would need a little bit of a refresher on the law on that.
But it's local until it isn't. If it's under. I live that. Right, right. But if it's undermining a statewide policy, I think we need to know that. So I would appreciate it, Jamie, if you could find that out for us. Thank you.
All right. Senate Bill 418 is on ice.
Is it on ice?
It's hold for now. Hold. Not ice.
Clarify here.
Sorry, yeah.
Do you want to do 391?
I'm going to do 391, yeah, Senate Bill 391.
Senate Bill 391 requires the Maryland Police Training and Standards Commission to annually review the report published by the Independent Investigation Division of the Office of the Attorney General and make any recommendations that MPTSC determines are appropriate based on that review.
This is done in consultation with MPTSC and the Office of the Attorney General. Submit a motion for favorable. Is everyone okay being recorded in the affirmative? Senate 391 has passed unanimously. All right, we're holding this one, holding this. All right, so let's go to Senate Bill 585. Yeah, we're good. That's the next list. We're doing. We're about to jump on that.
Senate Bill 585 establishes an exception to the prohibition against wearing, carrying, or transporting a firearm into the dwelling of another or onto real property of another under the provisions of 6-411 of the criminal law article for a person who has retired as a law enforcement official as specified in the bill and either has a best be described as a LEOSA credential or a wear-carry permit.
Hold on, sorry, there's a Senator Folden. Did we already add your name onto this one? Senator Folden wants to be added as a co-sponsor. Senator West would like to be added as a co-sponsor. Senator James would like to be added as a co-sponsor. There's been so is it okay adopting those amendments? Okay. Now the bill's before you. Has a minute. There's been a motion for a favorable. Second. Let's go do a. All right, Senate Bill, what is it, 585?
Did we just pass that?
Is it? Yeah, we did. Passes 8-2. All right, Senator Folden, we're going to go back to Senate Bill 710, which we're just going to amend, and then we're going to table.
So Senate Bill 710 creates a new offense of driving in a criminally negligent manner. So under current law, as was alluded to earlier, there is an offense of causing a life-threatening injury or death by driving in a criminally negligent manner. So this would establish a new offense that is just driving in a criminally negligent manner. Person would be guilty of a misdemeanor and subject to penalties of up to 6 months or a maximum fine of $5,000. There are two amendments that were just distributed. The first is number 223123/1. This also has the name of Sergeant Kep to the short title of the act. And the other amendment that was distributed is number 583623/1. This amendment, so just to step back a little bit, the way the bill was drafted is that it added to the existing provision which prohibited causing life-threatening injury by criminally negligent operation of a motor vehicle or vessel. What the amendment does is instead break this new offense out into a totally new section of the criminal law, and that was determined to be a better approach for a couple reasons. So one of the reasons was that in the existing provisions, there's a definition of criminal negligence, which refers to a result or circumstance of the negligence, which is not really appropriate for this scenario because this doesn't require the criminally negligent driving to result in any particular injury or death. So it was decided to kind of break it out and restate the standard in a slightly different manner. It's a little The other change that's being made by breaking it out into a new section is that the new offense would not apply to any conduct involving a vessel. So it would be just motor vehicles.
Wait, let's do this. Let's adopt the non-substantive amendment, which is 223.123/1. Is everyone okay doing that? All right, so then let's also adopt sponsor amendments. So Senator James, Senator Folden, Senator West. I'll hop on. Senator Smith, do you want to? Senator Waldstreicher wants to hop on this one.
James, Olin, West, Smith.
Waldstreicher. And Charles. Okay. Let's hold this amendment and further discussion on this bill until. Yeah, we're gonna hold the substantive because I don't want to discuss this. We're not moving this bill tonight, so we're, so we'll table that. Senate Bill 466, and then we're going to jump over to voting list 10.
So Senate Bill 466, this is the Attorney General's bill on vulnerable adults, theft of property by caregiver, family member, or household member. Just a refresh in your voting packet, there is a copy of the amended House Bill 604, and I'll leave it there.
So do you want to?
I'm reading the Attorney General's opinion or letter to us, and the question is to clarify or expand on the need for this bill, item, which is the third, which is a third way to go after an individual who's vulnerable or at the age of 68, but removing the deceptive, intimidation, or undue influence language. And somebody was going to find out what the Attorney General was driving at and where he's unable to prosecute people in this arena. So somebody's going to, and here she is.
Q.
Thank you.
My man. You know I do that because it's you coming up there, right?
I know. Rhea Harris, on behalf of the Office of Attorney General, I want to explain the bill. We could always get people on theft, but the problem is a caregiver that gets charged with theft and found guilty can go to another person and be a caregiver and keep doing it and keep reoffending. So this bill will stop the caregiver from reoffending because we're going to the exclusion that the Department of Health and Human Services has. So if you're found guilty of the theft and financial exploitation of a vulnerable adult, you will be banned from ever being a caregiver again.
So I didn't even have Attorney General language yet because the January 31st explanation of the bill does not match what you're saying, but that was always the original intention of the bill?
There was a letter delivered to the committee. I don't know if it was given to all of the members of the committee last week. Okay.
I don't have that.
So it was supposed to be further explaining that.
That changes the intent of what they were even talking about.
Yeah, this is so.
No, same one.
That's what I'm saying. It's
Financial exploitation of a vulnerable adult.
Did you get?
Theft and financial exploitation.
I think we're gonna have to, Mr. Vice Chair, I think we're gonna have to like hold this until we, because no one has that letter.
Yeah, I'm still asking your questions,
And,
but.
and that changes the entire concept of what we were talking about. Because that I get. But what we were talking about was entirely different about vulnerable adult versus the age versus the intent, like the malicious intent. You're talking about after it's happened once so that the caregiver is banned and can't
That's
do
the
that anymore.
exclusion part, yes.
Okay.
Okay, but the 68 age is already in the code.
Yeah.
In
for a separate-
3-604.
I understand that, but that's actually, if we read that out a little, I think broader, it's not necessary to apply that here because that age, that standard is not, and I don't believe that standard to be appropriate in this. The vulnerable adult is the key component of this.
Right.
That's the key element. The age is irrelevant. It shouldn't be
To us, it's not irrelevant,
But
though.
I still, Mike,
So
what,
I think if we're going to hold it, I'm not sure the utility.
do I have to be
sorry.
rude?
I'm
Do I have
asking
to be rude
questions.
to
No, I'm
ask a
sorry.
question? No, it's fine.
I'm sorry.
If we're otherwise going to hold the bill, but if you'd like to ask the question now, that is of course okay, Senator James.
No, I'm fine.
Okay. Why don't we hold the bill till the end of today's voting session, let the chairman make a final decision about whether this needs to move forward today or can be held again.
Okay.
If we hold it to tomorrow, perhaps, I know there was a prosecutor who specializes that, and perhaps we could all join together.
Okay, sure. Yes, sir.
Here's my hypothetical. I go to my grandmother's house. She's elderly. I say, you know, Granny, I've always admired that antique gun on your wall. I would love it if you would give that to me. And she says, you're my favorite grandson. Of course I'll give it to you. And so I take it off the wall and I take it home. Now, under the language that I read here, it says a person may not knowingly and willfully obtain the property. Well, I did obtain it knowingly and willfully because I asked her for it, and she gave it to me with intent to deprive the individual of the property. Well, I'm depriving her of her property because I took it as a gift. And then I don't have it in front of me now, but we looked up the definition of deprive, and it didn't seem to differ from what I did when I asked her for the rifle and she gave me the antique rifle.
But she consented to it, so it's not your intent to permanently deprive her of the property.
Well, yes, it is, because she allowed me to take it. I took it home, and I can do with it, once I get it at home, I can do what I want with it. If I want to give it to my son, I can do that. If I want to give it to my best friend, I can do that. If I want to sell it, I can do that. So I've permanently deprived her of the property because she gave it to me. I asked for it, she gave it to me, I permanently deprived her of it.
Let me give you another hypothetical, if you don't mind, that may explain it more. We had a caregiver that had access to the bank card of the person they were giving care to. The person did not know that the caregiver was going to pay off her wedding and her honeymoon from the victim's card. So that's a permanent depriving her of the money willfully and knowingly.
Yes.
And she had the intent of never paying that back. And she did not ask for permission.
Right.
So you asked for permission. You said, I wanted to have the gun, and she said, you're my favorite nephew, and she gave you the gun.
Right.
That's a little different.
It is a little different, but the language of the bill we have right now doesn't seem to encompass the distinction between, and I think we need to work on a little bit to under current language, you have to show fraud or maliciousness or something. We're getting rid of all that. And so all we now have here is a factual scenario. And so we need to modify the factual scenario in a way which would cover your credit card situation, but then not render me subject to indictment because I got a gift from my grandmother and she gave it to me.
But you can see in the hypothetical that I gave you that the fraud and deception were not part of.
Yeah, I definitely see the distinction, but I don't think the language here draws that distinction. I think somehow we need to do that.
Okay.
That's my point.
So we'll hold the bill and we'll engage, tomorrow and the next day. So this is good. It's thoughtful deliberations. That's good. All right. So now we're going to move on to voting list 10, and we'll start off with Senate Bill 648.
Senate Bill 648 repeals provisions related to gubernatorial approval of decision of the Maryland Parole Commission to grant medical parole to an incarcerated individual serving a term of life imprisonment with the possibility of parole.
So motion for a favorable has been seconded. Is everyone okay being recorded in the affirmative? He's not here. I mean, it's. Actually,
Everything's gonna report out on Tuesday.
yeah, but here's the, so actually, I would like an amendment, I'd like an amendment on this, because I'm gonna jump on as a sponsor for Senate Bill 648. Senator Henson, Senator Love, Senator Waldstreicher, Senator Charles. 648. No, 648. All right.
Co-sponsor. I've got Smith and who else?
Sidnor, Waldstreicher, Charles, Love, and Henson.
I can find it, I might be a co-sponsor, but I can't find it, so just leave me off.
Okay. All right, so okay, I'd like to move the sponsor amendment. Is everyone okay adopting the sponsor amendment? Okay. Now, hold on. All right, so we've.
James also?
Yeah.
All right, Senator James. All right, now, sorry. So now the bill's before you as amended. The motion's for a favorable. Second. Is everyone okay being recorded in the affirmative? Excellent. So.
Oh, yeah, no, I'm good. I'm not leaving.
All right, so we're on Senate Bill 181.
Do you want me to read it?
Yeah.
Like, 'cause we are doing a series on that. Senate Bill 181 alters the eligibility for the Maryland Parole Commission to grant individuals medical parole, and it also creates a new grounds for parole, which could generally be referred to as geriatric parole. There is an amendment in your packet. It's number 283-328/1. It makes a number of changes. I'll walk through it in the reprint. So starting on the bottom of page 2 and to the top of page 3, it alters the definition of chronically debilitated or incapacitated, which is one of the key factors to consider in the eligibility for medical parole. And the intent of the new amended language is to sort of partially mirror the federal language that exists that governs compassionate release in the federal system. So it would be having a diagnosable medical condition that is unlikely to improve in the future and substantially diminishes the ability of the individual to provide self-care. That last part is specifically the part that is modeled after federal law. And as you know, the bill currently drafted, that also includes conditions such as dementia or severe permanent cognitive disabilities if those disabilities meet the same definition. Moving down on page 3 to around line 24, it alters the eligibility for medical parole. So as the bill came in, it essentially required two things in the alternative. It required chronic debilitation or incapacitation or a terminal illness, and which would require extended management with healthcare needs better met in the community, or that the individual has been rendered physically incapable of presenting a danger to society. So with the amendment, that or would become an and, although that second ground would be modified a little bit. So essentially, it would be a two-part, there would be two requirements. First, that the individual is chronically debilitated or incapacitated or suffers from a terminal illness, which requires extended medical management that would be better met in the community, and the person has been rendered physically incapable of presenting a danger to society by the condition, or that the individual is no longer a danger to public safety. Moving on, in the reprint on page, starting on page 8, it alters the eligibility for this new geriatric parole. So when the bill is drafted, an individual would have to be 60 years old and have served at least 15 years of the sentence. With the amendment, that would become at least 65 years old and served at least 20 years of the sentence. Moving down to line 20 on the same page, the amendment alters the way in which essentially a person receives hearings for geriatric parole. So with the way the bill was originally drafted, an individual would be considered for parole, for geriatric parole every 2 years. Under the amendment, essentially, instead, what it would say is, once you're denied geriatric parole, you may not have a subsequent parole hearing for geriatric parole for at least 5 years, unless the Parole Commission finds that extraordinary and compelling circumstances justify an earlier subsequent hearing. That extraordinary and compelling circumstances also is drawn from federal law around compassionate release. Moving on to the bottom of page 9, the amendment also adds a repeal of the current provision in the criminal law, which essentially provides for geriatric parole. It's somewhat of an outdated provision, which is no longer relevant with the new provision being added, but it is an existing law that actually only applies to people who have been convicted of 14101 crimes of violence. It's sort of an anachronism, so the amended bill would be repealing that provision. And then finally, on the bottom of that page, onto the next page, there's uncodified language which essentially directs the parole commission to prioritize parole hearings for medical and geriatric parole. The understanding we got from the parole commission is that they try to do this already, but given that there would probably be an initial surge of these applications, I think the decision was made that it made sense just to kind of put it in the bill and tell them they need to consider these expeditiously as they can.
So, do you remember how many people are eligible?
Was it like 80 or something?
Yeah. Okay, so I've never experienced this before in my time down here. We actually had a work group with the public defenders and the state's attorneys, and a couple other senators were there, and everyone walked away in agreement and has blessed off on this. So we're going to be in receipt of a letter from the public defender and MSAA, both sponsoring this bill that we're about to adopt, this amendment, hopefully, and move forward. So I've never seen anything that's I think it's amazing, and I also think this will make a significant, yeah, there you go. That's right, with prayer, all right. So there's a motion for favor for the amendment. It's been seconded, and now the bill's before you as amended. Is there any? Yeah, so would I actually, so can we do a sponsor amendment? Does anyone, not want to be on it, all right, so we'll do Senator Muse is already on it, or Senator Muse, do you want to be on it? This is your place, Senator West, Senator Sidnor, Senator Smith, Senator Charles, Senator Love, Senator Henson.
No, sorry.
Everybody except Senator
I don't want to be.
And no.
That's only because I have to read this book, I vote no, not be on the.
So Sidnor, Henson.
I think it's Smith, West, Muse.
See what? That's awesome. So now the bill as amended is before you. Motions for favorable?
Second.
Okay, second. Okay, so, MDJ's down. And then McKay's absent, Fulton's absent, or excused. And everyone else is up. Mhm.
Everybody else is up.
Yeah, what is it?
Yep, it's 8-1.
Okay, so Senate Bill 181 passes, what is it?
8-1.
8-1 as amended. We've got 2 excused and 1 down, yeah. Okay. All right, that concludes the voting for the evening.